Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone, and happy Sunday. My name is Pam Esquire, also known as Your Law Intellect. If you are new here, welcome, welcome, welcome. If you've been here before, welcome back. We are here to talk about all things legal. We have the documents, we break them down. And today we're going to talk about attorney Tyrone Blackburn. Now, I'm giving him a little bit of heat, you know what I'm saying, on some of these cases. He was mentioned in a couple of complaints that we recently went over, such as Friday when I talked about T.I. He was also mentioned, I believe, in a complaint that had to do with T.D. Jakes as well. So his name pops up. And, sometimes the cases be seeming a little shaky, Well, your boy Tyrone then hit a lick. Yes, my brother counsel has dodged paying sanctions in the case that he has where he represents Rodney Jones. That was a case we talked about a while ago. That was one of the cases that were early on when all of the Diddy things started coming out. He represents Rodney Jones, who said he was a music producer and he produced some of the songs on the Love album. I know at one point Rodney did a whole GoFundMe. He trying to get his money off of Diddy. He said Diddy basically finessed him out of money, and then he was like out of his money that he was owed for the work that he did. And he had this long complaint, and we went over part of it. I don't think we went over all of it because it was several pages. But in that complaint, he made allegations not just against Diddy, but he made like some type of civil RICO type situation of which UMG and Motown and all these CEO of UMG and Lucius LeGrand, it was all these people that were connected to it under the theory of you had knowledge somewhat of what Diddy was doing and you still decided to work with him. So the money that he made was used for certain purposes to kind of help fund what he was doing. It was kind of a circular argument, And so the UMG defendants immediately, this Universal Music Group, they immediately were like livid. Similar to like how Jay-Z's attorney is, that's how their attorneys were when they first came out. They were like, you better dismiss this right now. There's no truth to this. This is ludicrous. This is crazy. And they sent Blackburn what's called the same notice that we went over on Friday. So it's kind of eerily, similar from that standpoint, of which they sent him a notice to let him know, hey, listen, this is not based in fact and or law. And because of that, you need to dismiss this. And so what happens is when you do file it, when you give a person notice, the clock starts ticking where they have what's called a safe harbor. And the safe harbor, and this is in federal court, the safe harbor allows the person 21 days in order to do whatever, dismiss the case or whatnot. So before that they can even file the actual motion for sanctions. Well, in this case, as we will read, it sounds like Rodney Jones actually did decide to dismiss the case within that safe harbor period. However, the UMG defendants was still trying to come after him like, nah, you shouldn't get away this easy. We want the court to use its discretion to sanction you anyway. Well, the court, they had oral arguments a few months ago. And the court on Friday, when everything else was happening, everything, like I went live twice on Friday, so I wasn't going to go live about this. I figured I'll give it a rest for a minute and then come back and give Tyrone Blackburn his own day because he deserves it. And this came down on Friday as well, of which an order came down from the court where he won't be sanctioned for filing against those UMG defendants. So that is the summary of what we are going to go over. And I want you all to keep in mind what we just went over Friday related to Jay-Z and kind of see how this go. They're basically saying the same thing. They're going to try, they want to file first Rule 11 sanctions as well. However, they gave them the notice of it on Friday and they're asking the judge not to give them the 21-day safe harbor. They want them to have a day. Okay, but they filed it on Friday. The courts was closed, so it's kind of like, so we'll see if the judge actually shortens that time, because in Jay-Z's, they're like, every day that this is out here, it's ruining his reputation and it's affecting his family and affecting him financially. So they don't want Busby to get 21 days. They trying to get it where you got 1 day to take this down, and then we should be able to file a motion for sanctions against them. So that's just the summary. Make sure you guys come in and hit the like button. I hope you guys are having a fantabulous Sunday. Yes, please. Yes, please. Yeah, Lions didn't do so well today either. So I understand, Lisa. I understand. So when we go through the document, Find 9J, they'll explain some of the stuff in there, whatever is not explained, because I kind of glanced over it. I wanted to get to the bottom line and see what the conclusion was. So if I'll see, usually they put case law in there that explain things like that to you. So I don't want to be redundant. So if they don't, then I'll explain whatever questions you guys have after that. But yeah. Okay. Andrew said, I bet he's like, woo. I was saying shoe form, shoe. It's rough out here. It's rough out here. You said you saw the neighbor rolled your eyes. That's not nice. He out, I told you guys, I told you guys how this was filed, how they tried to get sanctions from him and there was oral argument. I'm gonna follow up and say what the outcome is. I have no dog in the hunt, so I don't care which way it goes. I'm gonna report both sides regardless. I'm not gonna do no ridiculous clickbait on one side to make something way bigger than what it is. Like, oh my God, Diddy's doomed because he won sanctions on UMG. Like, I'm not doing any of that. I'm just gonna say what it is and present it to you like what it is. If you guys want to watch it based off my caption, that's cool. If not, that's cool too. There are plenty of people that are one-sided, they're salacious, and they embellish a lot. Because I've watched some other content creators. I'm like, where did you get that from? Because everybody's doing law now, right? Everybody's doing the law. So they embellish a lot of stuff that I know really means not much of anything, but they'll make it like it is. So yes. And then when some of you guys put comments and tell me about some of those content creators, I don't even respond. I just delete the comment, or I'll delete the comment or whatever when you put their names in there, because I don't even want nobody going over there and getting that type of embellishment that I've seen. But I see you guys trying to say hi to as many people as I can. Kelly and LLE. Early morning vibes. You said you caught a live. That's cool. I know a lot of times people just don't even get notifications. So that is good that you were able to catch the live. All right, let's get into this. I don't plan on being here forever. So yeah. Let's get into it. So this is the Rodney Jones versus Sean Combs, and this is the memorandum in order from case number 24 CV 1457. Let me give you the background. Well, they start at the top. For the reasons that follow, the motion is denied. So I already told you guys what it was. So, and the court didn't hold you up. You didn't have to sit up there and be like, dang, what's going on? So this is the background for those of you that aren't familiar with this case, because we haven't talked about it in months. It has plaintiff Rodney Jones brought this action against Sean Combs and an assortment of additional defendants purportedly associated with Combs, asserting a variety of claims based on Combs' alleged history of sexual assault and human trafficking. In each of 3 successive complaints, because what Jones did, he filed a complaint, then he filed another complaint, then he filed another complaint, and they kind of got longer. And I think he may have made some corrections in some of them, but it was about, I think it was like 3 complaints that were initially filed. In each of 3 successive complaints, Jones named several defendants affiliated with Universal Music Group, or UMG, including UMG itself, Lucian Grange, UMG's chief executive, Motown Records, a record label owned by UMG, and Ethiopia. You know, I was messing her name up back then, and I still messed it up now, so I'm just going to leave it alone. Who is Motown's chief executive? Collectively, we're going to call them the UMG defendants. So when I say UMG defendants, that's all of these names that I just read. Before voluntarily dismissing them from the case, so for those of you that don't know, he did all those names, he dismissed all of those. But before voluntarily dismissing them from the case, Jones alleged that the UMG defendants were responsible for Combs' misconduct through the rationale underlying the defendants' alleged responsibility changed between the first and second amended complaint. So between the first amended complaint and the second amended complaint, there was a shift in theories as to why the UMG defendants were responsible for Combs' misconduct. The initial complaint and first amended complaint alleged that UMG, Motown Records, Grange, and Ethiopia were the employer, parent company, sponsor, and respondent superior of Combs and participated directly in his criminality. And that's in the first amended complaint. That's what FAC stands for, that you see in parens. Jones then dismissed Ethiopia from the suit, and you can find that on the docket at ECF number 8, and updated his allegation against UMG, Motown, and Grange. The second amended complaint alleged that UMG, Motown Records, and Grange were liable based on a license agreement between Motown and Love Records that created a partnership between the entities. And that's, see, the SAC, which is the second amended complaint, and it has paragraphs 160 to 73. The first 2 complaints also claim Grange and Ethiopia attended Combs' alleged ex-trafficking parties. That was in the first amended complaint. But Jones dropped those allegations from the second amended complaint. Y'all keeping up? Y'all keeping up with all of these changes and adding in additions and droppings in second and first and third amended complaint? You guys keeping up with that? You might need a chart. We might need a doggone pie chart or something. Okay. Jones' lawyer, Tyrone Blackburn, that is who is on the thumbnail, filed the initial complaint on February 2nd, 2024. Although the complaint made it into the ECF docket, it was docketed with the notice of a filing error. So the first complaint that he filed had an error. All right. And Blackburn was instructed to refile it. On March 4th of 2024, Blackburn filed another version of the complaint with modest changes, but the same substantive allegations. And that's the first amended complaint. On the same day, the UMG defendants sent Blackburn a letter notifying him of their intent to move for Rule 11 sanctions thereby beginning the 21-day Rule 11 safe harbor period. That's what I was just explaining to you how this goes with Rule 11 sanctions. Is if I feel like you have filed something that is frivolous against my client, or you filed it for improper purposes, I have to give you a notice, like tell you my rationale behind it and tell you, listen, you need to take this down off this docket or take me off the complaint. And then if you choose not to, for whatever reason, you may believe everything you're saying is grounded in facts and law. And so they got 21 days to make that decision, whether they want to take it down or not. After the 21 days, then you usually can file a motion to go ahead with the sanctions. On March 27, 2024, defendants filed a motion to dismiss the First Amendment complaint. So on March 27th, you have the UMG defendants. They filed to just dismiss the case, which was sometime after they had already told Blackburn, like, you need to, this is your notice that I'm going to file for Rule 11 sanctions if you don't get rid of this ludicrous claims against my clients. So if you look in the footnote, if you're confused, they're confused, because it has, the parties appear to dispute whether the document filed by Mr. Blackburn on March 4th, 2024 is a, quote, amended complaint, created some confusion on the docket as to whether the complaint had been amended once or twice. Because this dispute is immaterial, the court does not resolve it. The court, like, whatever. Y'all not even in this case no more. So it don't matter whether it's the first, second, third, fourth, fifth, sixth, seventh, eighth, or ninth. Whatever. After several attempts to file a second amended complaint without the court's leave, so he tried to file a second amended complaint without requesting leave from the court. So since he has filed the complaint and obviously they answered on the other side trying to dismiss it, then you can't file an amended complaint without leave from the court or the court giving you permission. So apparently Blackburn was like, well, let me amend this. So he kept trying to file a second amended complaint without the court's permission. Then Blackburn received permission or leave, and that's found in ECF number 36. And then he filed a second amended complaint on April 12, 2024. Y'all following? On April 24, 2024, the UMG defendants filed an updated motion to dismiss the second amended complaint. So basically, when he filed the first amended complaint, which they don't know if it's really the first complaint or the first amended complaint, but the court was like, we don't even care. Tomato, it's immaterial right now. So when they filed the first amended complaint, the UMG defendants filed a motion to dismiss. So once you file a second amended complaint, then as the defendants, they had to answer to that. So they basically changed their title, probably the second amended motion to dismiss. Dismiss the second amended complaint probably had most of the same claims in there, and then they had to refile it so it could be attached to the second amended complaint. I know it's a lot. I know y'all. Just hit the like button before y'all get lost and leave off of my live, okay? This is a lot. So this is similar too. I know you guys have seen that with, for example, with Milagro Grams and Megan Thee Stallion, how what she did was she filed a complaint against Milagro Grams. Milagro responded with a motion to dismiss. What Megan did then was file a second amended complaint. So basically that means your motion to dismiss means nothing. You have to, it's moot. So some people were saying that Milagro lost because of that, but no, it's just some people do that as procedure so they can see what you're going to argue, and then they'll kind of correct their amended complaint so it can actually not get dismissed, because you telling us what you think is wrong with our complaint. So now I'm just going to amend it and fix it. So it has its pros and its cons when you decide to file a motion to dismiss as your initial pleading. So she filed an amended complaint, and now Milagro will have to do the same thing and just file a motion to dismiss based on the amended complaint. So all of them that was clickbaiting like, oh, she got smashed. Oh my gosh, she took a big L. It really was just procedural, where she didn't actually lose her motion. The court didn't rule on it. The court was like, it's moot because we're not going by the first complaint anymore because they amended it. Let's go. On May 14, 2024, Blackburn moved to voluntarily dismiss all the claims against the UMG defendants, to which the UMG defendants consented. Of course they are. Like, how do you call and say, I'm about to voluntarily dismiss you out the case? Do you agree? Like, they're going to say no. So they consented to it. In his motion for voluntary dismissal, Blackburn attested that, quote, based on his examination of all the papers submitted in support of both motions to dismiss, he has concluded that there is no legal basis for the claims and allegations that were made against the UMG defendants. So he's basically saying there's no, he doesn't find any legal basis or any law that would support his factual allegations, support that something was wrong legally on what they did. So Blackburn withdrew the claims against the UMG defendants within the 21-day safe harbor prescribed by Rule 11C2 of the Federal Rules of Civil Procedure. So when he filed that to dismiss, he did it within the 21 days safe harbor. 3 days later, on May 17, 2024, the UMG defendants nonetheless moved the court to sanction Jones and Blackburn under its inherent power and 28 U.S.C. Section 1927. So basically, UMG was like, Blackburn and Jones, that's cool, but we don't like the fact that you even filed this in the first place. So we still gonna move for sanctions, even though you did file it within the safe harbor. Of course, Blackburn opposed their motion on June 3rd, 2024, and the UMG defendants replied on June 7th, 2024. Subsequently, the other defendants in the case moved to dismiss the operative complaint for failure to state a claim. Y'all up to speed now? Huh? Y'all got it? Y'all got it? Thank you, Blaze, because I'm like, they probably like, oh my God, Jesus. Yes, professor, I'm wondering where he got his degree because standard processor does not being followed. Listen, if everybody confused, we gonna be confused too. All we know is a bunch of complaints filed. UMG said, listen, bro, what you're doing against my clients is not based in law or fact. We don't know what you're talking about and what you're trying to make up on our end. So what we're going to do, we want you to dismiss this case, or we're going to try to file a motion to sanction you. Within the 21 days that he had, that's exactly what Blackburn did, was file a motion to dismiss the case. Then after he filed the motion, the UMG defendants was like, that ain't even good enough because you filed all these different amendments and you could have been dismissed this case, is really what the crux of their argument is. Like, you still could have dismissed this and you chose not to. So this is the legal standard for those of you. And I think it's imperative to go over because, again, this is exactly what's going on with the Sean Carter Jay-Z case, where his attorney has filed a notice and put Busby on notice as of Friday. You got whatever. Well, he trying to give him 1 day, but he really has 21 days under the safe harbor to do something about this case. Busby, though, however, may feel like he believes his client and he's gonna go forward with it. But again, we'll see what happens with that. See what the court says probably tomorrow or sometime this week. So this is the legal standard. Under Rule 11, a motion for sanction must be served on the opposing party first, and it may not be filed if the challenged conduct is withdrawn or appropriately corrected within 21 days after service of the motion. You get that? So basically, if you're going to ask for a motion for sanction, you serve it on the other party without filing it to the docket for like us and the public to see. You serve it and you let them know that you're going to get, that you're trying to request sanction, have your law, have all that stuff in there as to what your rationale is. And then they got 21 days in order to do something about it. After the 21 days, then you can go ahead and file it with the actual court. Because Jones and Blackburn withdrew the offending allegations within Rule 11 safe harbor period, The UMG defendants have instead asked the court to impose sanctions under two different sources of authority. So they said because he withdrew it under the safe harbor, we still think that we got grounds for him to be sanctioned anyway. And they use 28 U.S.C. section 1927, which provides that, quote, any attorney who so multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. So that should answer your question that you asked in the beginning. Fin 9. I know I'm probably messing your name up, but yeah. To succeed under Section 1927, a plaintiff must demonstrate, quote, clear evidence that 1, the offending party's claims were entirely meritless, and 2, the party acted for improper purposes. And they have case law, Revson v. Sneak. And the second prong is bad faith can be established by inference from completely meritless action. And see, that's what makes it kind of difficult, because if a client comes to you and they attest to it and say everything I'm saying is the truth, and they sign their name and their signature and all of that, then you have the right to believe your client, no matter how absurd it may sound. An award under Section 1927 is proper when the attorney's actions are so completely without merit as to require the conclusion that they must have been undertaken for some improper purpose, such as delay. Awards pursuant to Section 1927 may be imposed only against the attorney, not the client. So under Section 1927, you can only impose this against the attorney. Your client is fine. A federal court may also exercise its inherent power to sanction a party. That means Jones could have been sanctioned, or an attorney who has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. That's another way. The standard for imposing sanctions pursuant to the court's inherent power is the same as that under Section 1927. 1, the offending party's claims were entirely meritless, and 2, the party acted for improper purposes. Importantly, whereas each of Rule 11 in Section 1927 reaches only certain individuals or conduct, the inherent power extends to a full range of litigation abuses. This form of sanction power works, quote, to fill in the intricacies left by existing rules and statutes. However, while the Supreme Court has made clear that the district court has inherent authority to sanction, such sanctions must be imposed with restraint and discretion. So don't just be going around like, you get a sanction, you get a sanction, you get a sanction, you get a sanction. Like, you're supposed to have some restraint. Just because the court has the power, you don't necessarily have to utilize this power. That's why people don't understand when people get sanctions. It is a big deal when it happens, because oftentimes judges or the court will refrain from sanctioning individuals and attorneys. Finally, while Section 1927 sanctions may only be imposed on an attorney, sanctions under the court's inherent authority may be imposed on a party as well. Before punishing actions taken on behalf of a client under either Section 1927 or its inherent authority, the court must first make an explicit finding of bad faith. Negligence or recklessness alone does not suffice. Moreover, a sanction of attorney fees, whether premised on a lawyer's representational or non-representational conduct, must always be supported by a finding of bad faith. So the operative term here is bad faith. This stands in contrast to Rule 11 sanctions, which on a motion by opposing counsel may be imposed for objectively unreasonable conduct in the absence of subjective bad faith. Then they got the case Muhammad v. Walmart, which stands for the proposition that underlying the Second Circuit's approach is the recognition that sanctions imposed pursuant to the court's inherent authority may be levied only upon a finding of bad faith, and the requirements. So basically, they don't have to have a safe harbor that protects attorneys and parties from much more innocent conduct that may be sanctionable under Rule 11. Discussion. Because the standards for imposing Section 1927 and inherent authority sanctions are the same, the court evaluates them together. Jones and Blackburn have already admitted, and complying with Rule 11 and withdrawing the relevant claims, there is no legal basis for those claims. So the crux of the inquiry is whether there is clear evidence that they acted with subjective, not objective, but subjective bad faith. While Jones and Blackburn are not formally shielded from sanctions by a safe harbor withdrawal, as Blackburn is from Rule 11 sanctions. So the Rule 11 sanctions basically is a safe harbor for the attorney under the Rule 11 sanctions. However, when the court uses its inherent power, there's really inherent authority. There's really no safe harbor for that. So it's two different rules, right? Their willingness to voluntarily withdraw the offending claims is still somewhat persuasive evidence that they were not acting in bad faith. So the court believes, because the Blackburns made the initiation to go ahead and file a motion to dismiss the case and to withdraw, that it's leaning more towards he was not acting in bad faith. Sanctioning them despite their timely withdrawal of the offending claims, quote, would have the unwanted and undesirable effect of rendering Rule 11 separate motion and safe harbor provision meaningless. So if we sanction you anyway and you pulled it out within the 21 days, the court is saying it basically makes it meaningless to even have a safe harbor. If you still can pull your complaint or take them out of the complaint, pull the claims as it pertains to them, but they still risk being sanctioned. Like, it basically takes away from the purpose of what the safe harbor is. Moreover, while defendants attempt to make hay out of the fact that Jones and Blackburn technically filed 2 amended complaints, the court is not inclined to hold that against them for purposes of this motion. The initial and first amended complaints do not differ greatly in substance. And it appears that the first amended complaint was filed primarily because minor mistakes, an erroneous title and cover sheet, affected the filing of the initial complaint. Of course, Jones and Blackburn could have withdrawn the claims in the 7 days between filing the initial complaint and the first amended complaint, but defendants did not reach out to them in that short window of time, and there is no reason to think that they had more information available to them on March 4th than they did on February 26th. So according in the footnote, it says, based on the UMG defendant's memo of law, it appears that the first time the UMG defendants notified Jones and Blackburn about the problems with his claims was after the filing of the first amended complaint on March 4th, 2024. We read a lot of those letters too, because they were fighting back and forth, like how Spiro and Busby was doing. They were doing that in this case. Nor were the complaints allegations themselves so outlandishly and obviously false that the court is willing to infer bad faith from the implausibility alone. So the court also looked at what was alleged against the defendants, and they felt like it wasn't so outlandish and like ridiculous and so far-fetched that I'm just going to infer that it had to be in bad faith either. Across the various complaints, Jones and Blackburn made 2 general kinds of allegations to which the UMG defendants object. First, the initial and first amended complaints allege that Grange and Ethiopia personally attended parties hosted by Combs and attended by Jones. Jones and Blackburn modified and then withdrew these allegations once the UMG defendants objected to them. That is between the UMG defendants' March 4, 2024 letter and the filing of the second amended complaint. Even when a quote case should not have been brought in the first place, Section 1927 and the herein authority sanctions are generally not aimed at a plaintiff's pre-filing conduct. That is particularly true, whereas here, Blackburn's client attested under oath to the veracity of the allegation. So that's what I was talking about earlier. So it sounds like Jones actually signed it. So his attorney had every right, which we assume that he read it. His attorney had every right to believe the client and say, "Oh, this sounds plausible. It's a credibility issue. He can testify to what he saw. That's considered evidence as well." Now, whether the jury believes what he says is a whole different conversation. But his attorney had the right to believe what his client said. Please, guys, show your faith in me. Hit the like button. I know, I know it's confusing. I'm doing my best, okay? I'm doing my best, but they were just as confused too, okay? That's why I did the summary, so you guys know the bottom line. But I'm trying to break it down primarily because sometime this week we'll probably be back talking about Rule 11 sanctions because of what just happened with that interview with Jane Doe, who the attorney, who Busby had her, I guess, fly from Alabama to do an interview at his office with someone with in Texas. And there's been a lot of inconsistencies, and she's acknowledged those inconsistencies. And I think based off of that, they're trying to say, Busby, you knew this or something. I don't know. But we're going to see. It's going to be a lot of back and forth between Spiro and Busby as they've been doing since this complaint been filed. It was filed literally, last Sunday? And we've talked about it every day. They've been something filed. They haven't even answered the complaint yet, but something has been filed every day on that Jay-Z case. So let's continue as you guys hit the like and subscribe. Okay, so and withdrawing, I'm reading a footnote 7. And withdrawing these claims, Blackburn admitted that they lacked a legal basis. But neither Blackburn nor Jones has admitted that the factual basis for the claims was fabricated, much less that they were fabricated for improper purposes. Lawyers and their clients may decide that their claims are legally insufficient for any number of reasons, and the timely withdrawal of the claims once their flaws were pointed out by the defendants provides some evidence suggestive of good faith. So basically the court is saying, listen, they might have withdrew it and said they don't have a legal basis, but they may have thought they had a legal basis based on the facts. They didn't say they made the facts up. They just don't have any law that any cognizable claims for the facts that they have. So the court is like, well, once the defendants pointed out how you have no legal basis for whatever you're trying to accuse them of, he withdrew it. So the court is leaned towards that it was not done in bad faith, because as soon as it was pointed out to you, you decided to fix it. Second, the UMG defendants object to the various complaints allegations that there was a, quote, partnership between Motown Record and Combs' own label, Love Records. According to defendants, quote, there was no partnership, only an arm's length license agreement, end quote, which defendants attached to their declaration in support of their motions to dismiss. While Jones and Blackburn did have access to the license agreement before filing the second amended complaint, there was sufficient circumstantial evidence of a partnership that the court declines to infer bad faith from their misreading of the contract. So basically, yeah, okay, it was really a licensing agreement. He said they were in a partnership. The court was like, well, they could have just misread it, and I'm not going to say that's bad faith just because they didn't know the difference. Specifically, UMG posted about a partnership with Mr. Combs on a LinkedIn page, and Motown Records posted about a partnership on his website. So I guess now these websites about to be very, very specific on what words they use, but because they used the word partnership, Blackburn was doing his Google investigations and was like, "Oh, they're partners. Oh, he's a part of this stuff too that Diddy is doing." So that's where I guess the partnership term came from, but it really was just a licensing agreement. Given the court's determination that Jones and Blackburn did not levy these allegations in bad faith, it also concludes that Blackburn did not so egregiously misstate the applicable law with respect to a RICO and the TVPA as to warrant sanctions. While such claims may have ultimately failed regardless, they were not so thoroughly without a basis that the court can infer bad faith from their assertion alone. So the court couldn't just say this is so wild that it didn't make any sense at all. So therefore, they're not going to infer bad faith based off of that. Certain other factors also weigh against a finding of bad faith. Quote, while plaintiff's faith in his claims was clearly misguided, its decision to continue with this suit weighs against the conclusion that this litigation was undertaken simply to score an easy settlement. Let me read this footnote. Plaintiff directly based on, let me see, this was the court also declines to exercise its discretion to sanction plaintiff directly based on the apparent falsity of these allegations. Plaintiff alleges that on various occasions, Mr. Combs drugged him, leaving him dizzy and confused. Under these circumstances, the court cannot conclude that there is clear and convincing evidence that plaintiff fabricated his allegations against the UMG defendants in bad faith rather than simply being mistaken. The court is also mindful of the chilling effect that imposing sanctions on a party like Jones could have on future victims of actual abuse. So the court also is keeping in mind, like, hey, we sanction him, then other people, other alleged victims will be like, I'm not about to sue, shoot, because they might turn around and think I'm lying and then they sanction me for it. So that's another factor that weighed in favor of Jones. The UMG defendants provide no evidence that Blackburn attempted to coerce them into executing a rush settlement. Now, we know that that's the allegation that Jay-Z has against Busby and them, saying that prior to, he was like, we can go do this mediation and we can just get this out the way. And so that's why Jay-Z filed the lawsuit against Busby. But apparently Blackburn, there's no evidence that he tried to coerce them into executing a rush settlement. And while the allegations in this case are certainly salacious and threatening to defendants' reputations, the harms that lawsuits like this one seek to avoid are commensurately grave, and remedial statutes like the TVPA are to be construed liberally. Finally, it is not clear that Blackburn has engaged in a pattern of litigation designed to evade previous rulings. That referral, however, okay, so then it has defendant. Remember, there was a judge who referred Blackburn to the grievance committee. So this was actually used, has been used in different lawsuits as it pertains to Blackburn. So thank you, Lisa, for the Cash App, hun. I appreciate it. So it talks about that, the actual referral. Defendants point to Judge Coates' referral to Blackburn to the SDNY Grievance Committee. That referral, however, was for Blackburn apparently recurrent failure to investigate the existence of either jurisdiction or venue. So they're saying that investigation was he was filing them in the wrong courts. He wasn't making sure that they were in the right courts. And it was the allegation that he was purposefully filing them in New York because the Southern District of New York has a lot of celebrity and high profile people. So that was supposed to be a way for you to be able to pull the docs quick. Because, in federal court, there's various platforms that you can just pull the documents easy. Some state courts Some of them are online, some of them aren't. Some make you go to the courts to get them. I know here, most of our courts, you got to go to the courts and try to get copies. So they don't have them readily available. So it was an allegation as if he was doing this purposefully so that he can get the notoriety and get the press from it, is what they were alleging. So, but it wasn't because he was just filing false claims. It was he was in the wrong court. So that referral, however, was Blackburn's apparently recurrent failure to investigate the existence of either jurisdictional or venue, not for the sort of misconduct alleged here, bad faith fabrication of allegations. Judge Coe also made no finding of bad faith in Zagrowski and declined to impose even Rule 11 sanctions. So even when Judge Coe said, I'm going to refer you to the bar, Judge Coe didn't even do Rule 11 sanctions against him either. Therefore, while Blackburn may have acted incompetently at times, well, gosh, that wasn't nice, Judge. While Blackburn may have acted incompetently at times, there's insufficient evidence for the court to conclude that he has engaged in a pattern of bad faith. So then in footnote 8, Judge Coe did observe that a reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. While this may be true, a reasonable inference is not enough here. Rather, a showing of bad faith by clear and convincing evidence is a prerequisite to imposing sanctions under both Section 1927 and the district court's inherent authority. In conclusion, for the foregoing reasons, the UMG defendant's motion for sanctions is, put it in the chat, denied. Plaintiff's motion to voluntarily dismiss all claims in the second amended complaint against Grange, Motown Records, and UMG is granted, and those claims are dismissed with prejudice. The clerk of the court is directed to close the motions on the docket number 49 and 52. So ordered. Blackburn has not been sanctioned. So, shout out to you, Blackburn. They said you didn't do it in bad faith. They said you might have been a little incompetent at times, okay? Might not have knew how to file the stuff right. May not have knew what jurisdiction you was in, you know, but it wasn't, I can't say it's bad faith. That's what the court said. You said, yikes, a judge confirmed my curiosity of where he got, you know what? Andrew said, baby, this won't help Miss 5-hour drive, you know. So now you guys know the standard of what the court will look. Every judge is different though, but generally speaking, we can assume that this is kind of how the judge would look at the complaint against Jay-Z, and perhaps they may think that what did Busby say? He said another firm vetted it. She says she's willing to take a lie detector test. She's adamant that all this stuff happened. And so, but the difference too is he got the settlement stuff he was trying to do, the demand he was trying to do beforehand. He has the back and forth that they've having, the investigation. I seen some clip where I guess Jaguar Wright was alleging, I guess, that Busby's firm called her. I was like, oh, it's getting real deep if Busby calling her to try to talk to her. But yeah. So they're supposed to talk, I guess, on Monday. I'm sure if they do, it'll be all over this here internet, but he might not do it now that he knows that she was allegedly, if that was from his firm, that she was live when all that happened, he may not talk to her. But you said they're making, Passport Shogun said they're making excuses for him. Andrew, that's not nice. I'm gonna hit the gavel. It is so ordered. He said, well, I'm a neutral intellect watcher and I must give props to whom it's due. Congratulations, Attorney Blackburn. Yes, give him his congratulations. Because I thought that was gonna be a close one. I didn't think he was gonna come out unscathed like that. And that was just because I did notice all those amendments, and I was like, I didn't know the order of them. So I thought perhaps they sent the letter for the safe harbor. I mean, for the notice, and then he had the 21 days, and then the 21 days, instead of dismissing it, he filed it again. So I didn't remember the order of it. So that's why I was concerned. Like, why would he keep refiling it if there's no basis in law? So basically, he had now acknowledged that even though he put those facts in there, they didn't say that the facts was made up. They just said there's really no cause of action for the facts that they provided. That's all. So dismiss with prejudice means they can't bring those claims back against those defendants. If you see something that's dismissed without prejudice, that means they can bring it back. So the judge has dismissed this with prejudice, so these claims are done. They can't bring them back at a later time. Elite Leo said Jag is now saying she doesn't trust Busby. She's full of it. She has no real evidence and she is not a real victim. That's why she won't seek any real justice for herself. She lied. That's from Elite Leo, okay, Jag? I don't want you coming for me because I seen you every time I'm looking down my timeline. Jag is going off on somebody, okay? She said it was AI. She didn't say all the stuff y'all saying she said, and I haven't watched her enough to know what I have a general idea of what she's been saying, but as far as her jumping on all the platforms and saying the things that she said, I don't know everything. But yeah, she's been a topic all weekend. Perhaps that's what she wants. Some people think that any publicity is good publicity. But we about to see, because I'm telling you, Jay-Z's attorney, Spiro, and them was already up in the office. They probably slept in the office this weekend. Elise said, yeah, I said it. Oh, gosh. But that's it, guys. That is the update on this guy Blackburn. Congratulations, So what do you guys think? Do you think the court made the right decision? You guys are the social media jurors. Do you think the court made the right decision that Blackburn did not file this in bad faith? Now, I do agree about the plaintiffs. I do think it will deter plaintiffs from filing with certain actual abuse or something. If it's like, dang, the judge believes that what I said is far-fetched, then other people will be like, my situation was kind of wild. So they may not believe me. I'm not trying to be sanctioned. I kind of feel that concept. But do you guys think the judge got it right? That's the first question. And do you think that applying how the law is to the facts of Jay-Z's case, do you think he has more of a chance of getting sanctions? My sister said she thinks some people need to hit the like button. That's what she said. Sheila said he withdrew it, so it's mute. So they got it right. She gonna say Jay-Z pays you if you're not on her side. Oh, I already been told that Diddy paid me. I'm like, really? I work way too hard for him to be paying me. Okay. I need to slow down some of my caseload if he paying me like that. So people say that now because the way this internet is, and I get it, some people speak from a place of trauma. So there's some people that I know that they claim they know Diddy, or I know they were in the industry and they were producers and they were women. And they have talked about writing sessions with different producers and just what a lot of women have went through trying to be in this industry that was male dominated back in that time. They were the gatekeepers, quote unquote. So, and how they would not give them the pay that they deserve and just all of that. So because they experienced that, every little thing that people come out with, they just want to believe it because they hate the person. See, the good thing about me is I have no feeling one way or another, except I may not like you. You have a personality I could live without. Like Diddy has a personality I could just live without. You know what I'm saying? Because he just, how he was acting and how it seemed like he was treating people on that Making a Band. That was years ago. So that was just me. But it's not like, I think he does not deserve due process. I think he does deserve his due process. I think he does deserve to be able to wage a strong defense. I think he deserves to actually be treated as if he is innocent until proven guilty beyond a reasonable doubt. Just like I believe that for anybody. But like I told you guys before, I do this for a living. So I don't have emotional attachments like some people have. Some of these people, you think they know these people. That's why I say all the time, like, I don't know these people. It's people that's been accused of way worse in our local communities that we don't even talk about. And people don't have that outrage in the person living around the corner, but everybody outraged about some celebrities that will never even give you the time of day. It's just very interesting to me. Mark said, did Tony Busby drop the case against Jay-Z? Not that I know of. I didn't see a motion to dismiss on the docket. But let me double check. Shoot, maybe I missed something. I seen a couple of titles that was inferring that, but they were reading the letter. The same letter we read Friday when they were asking for it to be dismissed. But that was it. That's what I was saying about this clickbait. We went over the letter from Friday. Let me see what happened. Nope, nothing has been filed since Friday. We already went over that letter. And that was just a motion for a conference because of that NBC article and sit down. Kelly said, yes, I agree. I'm not a Diddy fan either, but I don't believe all these allegations. He does have a right to be thought as innocent until he's convicted. That's it. Just give them, let people win fair and square. How do you think some people win on appeal, and then by the time the appeals process go through, the prosecutor's case is so stale that they don't want to retry them? So then they may have actually done what you said, but they're going to get off because you didn't do it right the first time. Do it right the first time. Then you won't have all these problems. People want to win and not be fair about it. Just follow the law and follow the rules of the court. Just do it fair and square. That's it. And that's what I said about Diddy. It's like, no, don't take pictures of his papers. I don't care if they say legal or not. What's your point of doing that? If you're looking for contraband, taking a picture is not going to help your contraband situation. If you think it's contraband on a piece of paper, because sometimes they do stuff with the ink and all of that, then you need to take the whole pad of paper. Why would you be taking pictures of it? No, you don't need to send over visitor laws on how many times the attorneys went and sat with their client. There are certain things that appears, it has the look of impropriety, even if it wasn't intentional. Just win fair and square. That's it. But anyway, thank you guys so much for joining on this Sunday. Please make sure you guys hit the like button and subscribe to the channel. Again, congratulations, Tyrone Blackburn. And good luck on your future endeavors with the rest of the case. That means he still has the case going against Diddy and all of those individuals. I think there was a motion to dismiss the companies. I get the cases mixed up, but I know when one of the complaints against Diddy, Bad Boys, was dismissed, like some of the companies have been dismissed. It might have been the one with Harv Pierre. I think the companies were actually dismissed, but of course the individuals, because it is he said, she said, the court can't really dismiss it unless based off of that, if it's he said, she said, unless there's like a statutory limitation issue or if it's the wrong venue, like for technical reasons. But as far as substantively, they're not going to do that at this early stage. That's it. See, everybody's congratulating you, Blackburn. Congratulations, bro. Now, I don't know if he's going to be representing Dwayne Youngblood. He is the man that has sued, not sued. He's the one that got sued by TD Jakes for defamation. He was the one, I guess, that sent a demand letter to TD Jakes, and TD Jakes is kind of alleging similarities with what Jay-Z and them are, like it was almost a shakedown situation or something. Said he asked for $6 million to settle the case. But Blackburn is licensed in New York. So I didn't see any pro hoc VJ to come there or any counsel there. So his answer, Youngblood's answer, is due like the day after Christmas, I believe. He was served on December 4th. So his answer is due like December 26th. So we'll definitely be back to see what that response is going to be. But again, I don't know if Blackburn is going to represent him on that because, again, he's licensed in New York. And I think New Jersey, I don't think, I mean, he can always pro hoc into Pennsylvania, but I didn't see any filings that happened. So we're going to keep an eye on that too. Most judges are former prosecutors. So they don't care about being fair to the defendant. Now, Passport Shogun, I'm with you when you kind of right. I'm not gonna say most, but I'm gonna say there are a lot of judges that are prosecutors in a robe, and that's what I call them. But we the people vote them in because we don't look at their background. So a lot of times the prosecutors do lean towards, if your whole life has been putting people away, then it's very rare you run across recently the newer prosecutors that I have come into contact with, they're a bit more liberal. Some of them are a bit more liberal, so they'll look at both sides. Plus, a lot of people are more into the law now, as you see on the internet, so it's a little bit different. But I would have to agree with that. Sometimes they do become prosecutors in a role, and if they have discretion, they lean towards the prosecutor. So, and I feel like they're not always fair to the defendants. Because I have a case where this is so crazy to me. So, this guy, I think he's been in prison over 30 years. And he's been trying to get out. And so he got an investigator. So what the investigator found was the Detroit Police Department keeps what's called a miscellaneous file. Check this out, y'all. Every time you turn over information to the prosecutor, it's supposed to turn it over to the defense attorney. So what is alleged is that in Detroit, back then in the 90s, they would keep a whole separate file. So if there was exculpatory or favorable evidence to the defendant, they'll just keep it in a separate file. So it's never turned over, so the defense attorney never knows about it. Fast forward, this guy gets an investigator to FOIA and ask for the entire file, and then also ask for the miscellaneous file because he heard about the miscellaneous file. They turn over a miscellaneous file where the prime person, the main witness that testified against this guy, he was actually the prime suspect. Like, they found the guy's ID in the victim's house. Somebody called the number and was like, this guy confessed to them, I guess, that they did it. It was all type of little stuff in the file. Like, are y'all serious? So now, of course, he's already did 30-something years. So now you're trying to get out, but the prosecutor is still fighting it. Why are we fighting that? Why are we fighting a new trial? I don't even understand that concept. But some people, they care more about winnings than justice, I guess. But that's the type of stuff that happens. This stuff still amazes me. Like, even though I've done it for a little minute now, it still amazes me some of the things and how people treat people and what they do to win. It's just absurd to me. It's so insane. But Kelly said that makes me so angry. You literally the person who, just imagine, the person who testified against you and they lying. You and the defense team, like, why are they talking about they came to my house and I was full of blood? Like, what are they even talking about? Y'all made up this whole story because the whole point was you were trying to get it off of you because you was the prime suspect, but the defendant doesn't even know that you was the prime suspect. Now the defense attorney, of course, on cross was like, you knew the victim, you knew how to cross them to try to make a little inference that maybe he was the guy that did it, but really didn't have no proof that he did it. It was just, really was no evidence that he did it. But the whole time there was actually evidence that could have corroborated that the guy who testified against him as the main person to testify is the one that did it. And you did 30-something years. That's just crazy to me. So like you go to prison and your kid too, and now your kid grown with kids of their own, and you're still in prison trying to fight to get out. It's crazy. It happens a lot. It happens so much. It's crazy. And then, like I said, it was another guy. They had a whole snitch ring where there was a guy who he was a professional snitch. So basically, the cops would give him the file, the discovery file with all the evidence against people, and then he would testify against them. Like you testify against 10 people 20 times until defense attorney started catching on, like, wait a minute, the ones that were on the court appointed list was like, how is this guy, like everybody's confessing to this guy in prison? Like I've had 2 different clients and he's the witness against them. Like something ain't right. So then that's how the investigation kind of started unfolding. But of course, that wasn't until people did like 20 years to find out that this guy was lying. So it's crazy. And then the older a case gets, the harder it is to even really investigate. Like you don't have, like now it's cameras everywhere, cameras in the street lights. People got Ring cameras. You can get cameras from the stores. You talking about the 90s? It's very, very hard. Then they don't keep the files like they should. Even though when you are accused of unaliving someone, you should keep the file indefinitely because people are going to keep probably trying to fight to get out until the day they die. But yes, it angers you. It pisses you off. Blaze said, in my experience, it's upsetting when the judge does not allow pictures of the deceased victims. I've never had that. When I did criminal defense and unaliving case, they had the picture was there. So I don't know. That hasn't been my experience. But of course, as a defense attorney, absolutely you want to try to limit how many the jury can see because you don't want them to necessarily make their decision on emotion. So you do try to limit it, or you will try to file a motion to try to not have it in or deem it inadmissible because it's more prejudicial than probative. But at the end of the day, like I've never had it where they don't have the victims pictures. But yeah, it's almost always the blacks who get wrongly convicted and incarcerated. You know, I could talk about this all day. I'm not even going to go down this rabbit hole. Y'all not going to get me on this Sunday. I just came on to talk this good hour to give Blackburn his flowers while he could still smell them. And now that I have done my job and I have explained that he has not been sanctioned, shout out to you again, Blackburn. Keep on keeping on, sir. Y'all make sure you hit that like button and subscribe. I'm going to get off here before y'all start triggering me about these wrongful convictions because I'm not going to do it today. Until next time, I'm going to holler at you later.